enough. Good morning. This meeting is meeting number 10 of the Standing Committee on Procedure and House Affairs for the first session of the 42nd Parliament. This meeting is being held in public and is televised at 1 Wellington. Today is the first hour of our meeting. We continue our examination of federal appointees to the Independent Advisory Board for Senate appointments pursuant to Standing Order 110 and 111. In the second hour, we will consider committee business, and I'll be chaired by Mr. Blake Richards. I remind members that in accordance with standing orders of the House, this committee's role is limited to an examination of the qualifications and competence of the appointee to perform duties of the post to which he or she has been appointed. Members may also refer to pages 1011-1013 of the House of Commons Procedure and Practice, OBB. Our witness this morning is Professor Daniel Jutras, who is appearing by video conference from Montreal. Professor Jutras, you have up to 10 minutes for an opening statement, and then we'll proceed to questions from committee members. And I don't know if you can see us and everything, but the floor is yours if you can hear me.
I can hear you, and I can see a general view of the room. Thank you very much, Mr. Chair. I'm grateful for the opportunity to appear before your committee, and if I may, as you indicated, I would like to take maybe 5 or 10 minutes to offer a brief opening statement. I understand that the objective of your committee is to assess my qualifications and competence, and I would like to focus on that, if I may. L'objectif, comme vous l'avez indiqué, d'évaluer la
The objective of this committee is to look at the contribution I could make to the work of the independent committee from an examination of my professional. I know you have my CV in your hands. I would like to take a few words to explain my professional career so far. I finished my law degree at the University of Montreal and in constitutional in Harvard University in the 80s. I'm a lawyer, member of the Quebec Bar Association since 1984. I'm professor at McGill for 32 years. My expertise in the law is civil law and comparative law. As you can see, I have also a sustained interest for constitutional law, an interest that has been shown in the mandate that I received from the Supreme Court of Canada to be amicus curiae in the Senate referral and amendments to Constitution. Between 2002 and 2005, I was on leave from McGill University to be executive legal officer at the Supreme Court of Canada as personal secretary to Chief Justice Beverly McLachlin. I was there to help her in all her activities, except, of course, decision writing. Outside of the court, I had a responsibility to liaise with the Canadian Judicial Council that look after the training of federal judges. Within the court, I had the responsibility with the media, with the clerk management program, and also the relationship with the court and the operational services of the court.
Questions on all of the elements of my CV that you have before you. I would like, before handing the floor back to you, to try and take a moment to connect my profile, qualifications, and competence to what I think might be helpful to the advisory board, and identify what I think those qualities might be. It seems to me key criteria to contribute, or key qualities to contribute to the work of the committee, begin with a strong reputation of personal integrity, reputation of sound judgment, and a reputation of absolute discretion. And I think I want to underline that much of the work, in fact all of the work that I did with Chief Justice McLachlin and her colleagues at the Supreme Court of Canada within the Canadian Judicial Council as well, involved extraordinary confidentiality, significant confidentiality and required, I think, demonstration of sound judgment. And I don't think I would have been appointed to this position without a very strong reputation of personal integrity. I point out that I think I have the respect of my peers and colleagues. I currently am the Dean of the Faculty of Law at McGill, and I'm also Chair of the Council of Canadian Law Deans, and recently received the distinction of Advocatus Emeritus, which is awarded by the Quebec Bar to distinguished members of the profession. Second, I would say an important qualification is independence and non-partisanship, and I'm not a member of any political party, nor am I a militant, and haven't been. Third, I think it's really critical to the work of the advisory board that its members have some experience with the evaluation of files, the ability to read CVs, read letters of recommendation, to do so in both languages, to work effectively in a group, in a collaborative manner. And I have to say this is pretty much my daily bread as dean. The work of the dean requires extensive participation in the evaluation of confidential application files and candidacies and work in groups and those kinds of assessments. And then finally, I would say it's useful to the work of the committee that some of its members, and ideally many of its members, have some understanding of the constitutional architecture of Canada, the role of the Senate, the legislative process at the federal level. And the work that I did in the Senate reference before the Supreme Court as amicus curiae obviously focused primarily on the amendment procedures, but in preparation for my oral argument and written briefs, I read just about everything that has been written in law and in political science about the Senate. So even though the Senate was not at the time, and I think, to be fair, is not yet my field of expertise, I can fairly say that I have a significant interest in the Senate and parliamentary proceedings, and good enough knowledge, I hope, to contribute significantly to the work of the advisory board. And with this, Mr. Chair, I'd be happy to answer questions, and I hand the floor back to you.
Thank you, Mr. Duchas. And just so you know how the questioning works on this committee, we have a round of four different people will ask you questions. They'll have 7 minutes. And then the next round, people will have 5 minutes. And the time limit includes both their questions and your answer. So if they ask a 1-minute question, you take 6 minutes. They don't get to ask you any more questions. So just so you know how it works here. And we're tight on the timelines, so every committee member gets a chance to ask you questions. So we'll start with Anita Vandebelt.
Thank you very much, and thank you, Professor Duchas, for being here today. You've obviously had a very distinguished legal career, and as you mentioned in your remarks, sound judgment, independence, these are all things that would be very important in this position. So I wonder if you could elaborate a little bit in terms of your background in law, and also what you mentioned that in your role as dean, you do have to evaluate CVs, letters of recommendation. If you could give us a little bit more information about that, about how you do that, and how you work collaboratively in doing that.
Okay. I think the work in law is perhaps less relevant to the work of the committee than the second aspect of your question. So let me be as brief as I can on the legal dimension. So my expertise, as I said, is in private law, comparative law, law of contracts, civil procedure, law of wrongdoing, which is kind of remote from the conversation that we're having today. But nonetheless, as I mentioned, I have a significant interest in constitutional law. This is this was the focus of my graduate studies at Harvard Law School, and I've kept up to date as much as I could, and also worked in some depth in constitutional law, in particular in my 3 years at the Supreme Court with Chief Justice McLaughlin. Very briefly on the work of the dean and the ways in which this involves consideration of files. There are multiple aspects of academic life that require assessment of files, from admission of students all the way to the process of promotion of professors and assessment of external institutions as well. And so I've, over the past 7 years that I've been dean, assessed countless files for promotion within my own faculty actually several files outside of my faculty, assessed as well, and wrote letters of recommendation in a variety of contexts that are both academic and professional. So it is both for university promotions and awards, as well as professional recognition, such as the distinction of Advocatus Emeritus.
I see that you won the Queen Elizabeth Medal in 2013. Can you tell us what that was for?
Well, I think the medal, if I'm correct in this, the medal was awarded to about 60,000 Canadians, which is a significant number of people, and I'm just one of 60,000. So I don't want to play this up too much, although I'm very proud of this. I think it was a recognition of significant contributions in the field of law and in academic life as well.
So there are a number of transferable skills that you see in addition to your legal background and your knowledge of the Constitution of law, in terms of just being able to bring people together, being able to assess, being able to judge different qualifications of various different people. You spoke of the fact that you are also the dean. I missed the exact title, but in addition to being dean of your faculty, you're part of a council of deans.
Yes, indeed. So the deans, all of the law deans in Canada gather around a table which is intended to address preoccupations and concerns of the dean. I'm also the spokesperson for the Canadian law deans, and so for the past 2 years, I've been the elected chair of this particular council of all deans of faculties and schools of law in Canada.
So you've been quite respected by your peers by doing that. Have you worked collaboratively? Talk a little bit more about the collaborative work that you've done.
So I do hope I'm respected. We work collaboratively, indeed. We just to give you an example, yesterday we worked together through email on drafting a shared statement on the faculty's response to the Truth and Reconciliation Commission's call to action. And so that requires quite a bit of collaboration, consensus. There are over 20 law schools in Canada, and we all have to agree on the text of this document. And so, indeed, it requires quite a bit of consensus and collaborative work.
I see a significant amount of work with the Supreme Court, including being personal secretary to Justice McLaughlin. So what do you see as potential transferable skills in terms of the work that you've done in the Supreme Court?
So the job of the executive legal officer is actually to be of assistance to the Chief Justice in whatever needs she may have. The Chief Justice, as you know, is an enormously busy person, has multiple responsibilities. In addition to her duties as a judge, she must run the court in operational terms as well as in collegial terms. She is the chair of the Canadian Judicial Council, which is the body that is made up of all Chief Justices of Canada and has responsibilities for all matters that are of significance to the judiciary. She also chairs the National Judicial Institute, which is, as I mentioned, the body that provides training to federal judges. And so I think the transferable skills there are twofold. One is that in this job, one has to be absolutely aware of the strict confidentiality of everything that happens within the institution. And of course, as you can imagine, being on the right-hand side of the Chief Justice in all of her responsibilities, sitting in an office right next to hers, helping her deal with the duties that I've just outlined, I was made aware of a number of things that had to be kept absolutely confidential. And I think this is a transferable skill here, obviously, given the significance of the process that we're engaged in and the need to preserve the privacy of the applicants and the confidentiality of the process. The other dimension is that the Supreme Court is a very important institution in Canadian life and in our constitutional architecture. And I think working in there and seeing the collegiality of the court and the way in which the court operates gives me a pretty good idea of the ways in which individuals engaged in public life need to behave. And so I think I can apply that kind of understanding to my assessment of the files that we have before us.
Thank you. So sound judgment, discretion, independence, are there other qualities that you see that you have that you would be able to bring to this position?
No, I think that would sum it up. The one that you did not mention is, I think, my familiarity with the constitutional role and structure of the Senate and its place in the Canadian government. Again, I don't want to claim expertise in this area. This is a very, very complex field, and there are many legal experts in Canada who know much more about the Senate than I do. But the work that I did for the reference, I think, gave me a sound preparation for this.
Thank you very much, Ms. Van de Belt. Mr. Reid. Mr. Scott Reid is the next question.
Thank you, Mr. Chair. Professor Jutras, thank you very much. While you are a very accomplished person, I suspect that you are probably somewhat socially uncomfortable with reading off your resume as this committee requires, and so I can appreciate the somewhat awkward position that puts you in. Being accomplished does not mean one is an egomaniac. The first question I want to ask you, just relating to today's subject matter, is whether you had the chance to watch the testimony of Minister Monsef last night, which dealt, before the Senate committee, it dealt to some degree with your mandate.
I saw the first 20 minutes. I had a meeting after that, so I missed the rest of. So I heard the presentations of both ministers, and I think the first 2 or 3 questions.
Right. One of the responses that came out very early, in fact, I'm not even sure it was a response. It may have been in Dominic LeBlanc's opening remarks, was that you required some extra time in order to complete your submissions, and that they have not yet been made. Is that in fact the case, and do you have a deadline in mind when you would be making your submissions to the Prime Minister?
So I'm
Hold on a sec.
not aware of it.
Hold on a sec, sorry. We have a point of order, Mr. Chan.
Again, the purpose of this examination today, Mr. Chair, is to look at the competency and the qualifications of the nominee, and I'm not quite sure the relevancy of the questioning of Mr. Reid at this time and whether, in fact, it is in order. And I take into account that, Mr. Chair, that you had provided some direction to the committee members at the beginning of this examination, and I would again suggest that the line of questioning from Mr. Reid at this time is out of order.
Seed.
Mr. Chair?
Yes.
In response to that point of order, I will just observe that what is appropriate is to, if you think something's out of order, is to inform the witness that in your judgment it's not necessary for them, if they choose, not to respond, and then that is then up to their discretion. And I'll mention further that the witness has a very impressive record of having dealt with issues that require discretion, and the witness is better qualified than anybody in this room to determine whether or not a question that one of us asks has the effect of putting him in a position of being unable to answer without violating his mandate. I think that is the appropriate course of action. Actually, not allowing the witness to answer and not allowing me to ask would be an inappropriate use of discretion.
Okay, I'm going to proceed that way for the moment, and I'm just going to reread just so you remind you of what the committee is allowed to do. And that is, the committee's role is limited to an examination of the qualifications and competence of the appointee to perform the duties of the post to which she or she has been appointed. So based on that, you can choose or not choose to answer that question.
Thank you, Mr. Chair. I think it's possible for me to answer in a manner that connects the question to competence and qualification in the following way. This is a demanding task, as I think members of the committee will understand, and people who sit on the advisory board must have stamina, energy, and the ability to work promptly. And I think my career until now demonstrates that I'm able to manage very intense workload and to work as promptly as possible in the achievement of the mandates that I've been given.
I actually did not mean that question, Professor Jutras, to suggest that you're incapable of moving quickly on issues. That was not the intent of the question. It was to determine when you expected to get back to the Prime Minister with your recommendations. Do you feel you're able to answer that question?
You don't have
So I'm not sure. Indeed, thank you, Mr. Chair. I'm not sure it relates to the mandate of your particular committee. I can say that we're working as promptly as we can, and we'll report in due course, having done due diligence in every respect.
Thank you. And Mr. Chair, in the event that you continue to rule questions that are germane to what's going on out of order, what I'll do is at the end of this witness's testimony, I'll be presenting a motion to invite him and the other members of the committee back to discuss these very issues that you keep on ruling out of order because they are important. Just giving you notice of that, Mr. Chair.
That's fine, and the committee has no choice. It cannot change its mandate for this particular meeting, so
no, but
it's
there is an overly restrictive interpretation, which I notice is being applied very aggressively to government members and has not been applied to members of the, to Conservative members. It has not been applied to government members on this same matter. It's quite striking, Mr. Chair. To the witness, you were involved as the private secretary of the Chief Justice. She also chairs the committee, I believe, that makes decisions regarding the Order of Canada. Were you involved in any way in that? I'm not asking you to get into the mechanics, but I'm just asking if you were involved in that.
No, not at all. This is one mandate that she performs on her own.
Okay, thank you. You mentioned you had been involved as an amicus curiae with regard to the reference case. Was that on behalf of an organization or on your own behalf?
So the amicus curiae is appointed by the Supreme Court, so I was not advocating on behalf of any organization. I was asked by the Supreme Court, along with co-counsel Mr. John Hunter from British Columbia, to present a brief and oral argument in addition to all of the briefs and oral arguments that the court was receiving from a variety of attorneys general as well as interveners in the Supreme Court. So the appointment came from the Supreme Court itself.
You have mentioned at some length your ability to understand. You didn't put it quite this way, but the concept of discretion is actually one which requires some degree of subtle knowledge to understand what it means, where its parameters are located, and I think that's what you were trying to point out. So keeping that in mind, I'd like to ask you about some of the proceedings that you're engaged in on the committee you're involved in cause you to face rules regarding discretion, what you can disclose in the future. Would you regard that as including the number of nominations that occurred in each province during the Phase 1 process? That is to say, would you say that you will not in the future be able to disclose how many nominations you received, not anything else, just how many nominations you received in each of the 3 provinces?
Once again, that's a process question.
Mr. Chair, you are wrong. That is going to a matter that the witness himself raised. He therefore is required to respond to this question.
He's not required to because it's process, but he can if he wants to.
So thank you, Mr. Reid. I think I will simply refer you back to Article 13 of our Terms of Reference, which require the committee within 3 months of submitting names of qualified candidates to the Prime Minister in the transitional process as well as in subsequent processes to provide a report then in both official languages, a public report that will be given to the Prime Minister that will contain information on the process, including the execution of the terms of reference, the costs relating to the advisory board's activities, and statistics, more pointedly statistics relating to the applications received. We have not written that report at this point, but I think it's fair to say that we will need to ascertain the level of disclosure that will be required in that context.
Oh, thank you. In the same regard, then, would you regard this as, and this is a matter that was asked to the minister, although I think after you stopped watching, the names of nominating groups, not the names of people who were submitting their applications, that clearly is intended to be confidential, but the names of nominating groups, a matter which I do not think is in your mandate stated as being confidential. Indeed, when I think your mandate was written, the Phase 1 process hadn't actually been dreamed up yet. But would you be willing to include that in your information in your report?
I'm sorry, I missed the last intervention.
Oh, I said you have 10 seconds.
10 seconds. Again, Mr. Reid, I would refer you back to the terms of reference and suggest that I don't think it's appropriate for me at this point to indicate in some detail what will be in that report before it's even written. I think it remains to be done at this point.
Thank you, Mr. Next questioner will be David Christofferson.
Great. Thank you, Chair, and thank you, Professor, for being here today. Appreciate it. Just for the purposes of full disclosure, you probably know that I and my party don't have a lot of use for the Senate. We just as soon see the thing disappear and gone. However, that's not the view that's prevailing right now. What I wanted to ask you was very similar to the questions I asked your colleague last time. I accept your qualifications. Quite frankly, given that any Canadian can be appointed, I think just about any Canadian can be on a board that approves the Canadian. So I have no problem with your qualifications. They certainly, from a professional point of view, if that's what is wanted, is a 100% professional person, I accept you're it. But I do want to speak to the issue of competency, and I want to approach it this way. One of the things about a democracy is accountability. And we on the House side have accountability built in every weekend when we're in our ridings, certainly every 4 years in elections. Not so in the Senate, but given the fact that accountability is an important trait of a modern democracy, what sort of traits would you be looking for in candidates so they would understand the importance of accountability and that would be part of their role, is not just as lawmakers, but also to be accountable for what they're doing. So when you're interviewing people and making these decisions, what sort of traits are you looking for in them that would give you the assurance that they understand accountability is an important part of our parliament on both sides?
Go ahead and you can talk about your traits and ability to do that. Whatever you want.
So I confess that I think that question is also slightly outside of the mandate of the committee, unless I'm mistaken in my understanding of what the topic of our conversation is today. So I'm not sure I understand how your question relates to my qualifications and competence. Could you clarify that for me?
Sure. You're the one that's going to be making decision about people and whether they're in front of you. And one of the things I assume you're going to do is satisfy yourself that they can do the work, that they have the stamina to handle what can be a busy workload. I'm suggesting that an important trait that Canadians want in senators is that they understand that accountability is part of being a parliamentarian. A parliamentarian covers both sides of Parliament, both houses. So what I'm asking is, what are you looking for when you're interviewing someone to satisfy yourself that they understand the importance of accountability?
So I think that goes to the mandate of the committee, rather a mandate of our advisory board, rather, as opposed to my personal qualifications and competence. And the mandate of that committee is pretty clearly delineated in its terms of reference. I think the minister has made it very clear what the qualifications and merit-based assessment criteria are. Those have been made public, and I think that is one of the key features of the work that we're doing. We're being as careful as we can to implement the criteria, qualifications, and merit-based elements that have been stipulated in our terms of reference, including, I might add, the idea of proper understanding of legislative processes, the role of the Senate, and its place in the constitutional order of Canada.
Yeah, I'm not real impressed with these answers, sir. I think it's very legitimate for me to ask you what you're looking for, because you're the one that's going to decide who our lawmakers are. Not me, not the Canadian people. It's going to be this committee. You get to decide, and all I asked you was, how are you going to find certain traits? And in this case, the trait was accountability, and all you want to do is play politics with it and tell me why you shouldn't answer the question. I don't understand. It's a very reasonable
Point of order.
question, Chair.
Point of order. Ms. Sahota.
Yeah, point of order. I believe the witness has done an excellent job at answering that question
Well, you
within the
would.
mandate of this committee, and Mr. Christofferson, is badgering the witness and continues to do so.
How can I be badgering? How can I be badgering when I can't get an answer?
Well,
All I'm asking, I think it's a very legitimate. How can it not be legitimate to ask them what they think as they're looking at someone making a decision?
The answer Mr. Christofferson is looking for goes to the qualifications of the potentially appointed senator, and not to the qualifications
I've
of the witness
played
before
this
us.
straight, Tara. I've played this straight from this process, even though we have no use for it, nor the Senate. But I have played this straight all the way through. And the first engagement of games, unfortunately, has come from the government's witness, who refuses and is trying to find a way not to answer a very reasonable question. And if I can't get the person choosing the senators to tell me how they're looking for accountability, how in the hell can we ever expect we're going to have senators that believe accountability is part of being a parliamentarian?
Can
Yeah,
ask a-
crickets. You know what? I'm done. And I'll support any action the Conservatives want to show everybody what a joke this is.
Okay, Mr. DeBerg. The next questioner is David DeBerg Graham.
DeBerg is my middle name, Mr. Chair.
David Graham.
I'm reading over your CV. J'ai quelques questions. T'as fait?
I've got a few questions for you. You worked abroad as well. You had 3 posts. You worked at Louisiana State University, amongst others. You also worked at Harvard and at Aix-Marseille. Could you talk a little bit about this experience, please? The work that you did there. Could I ask you to repeat the question? I'm not hearing very well. Yes, you worked on a number of occasions abroad as an assistant professor. You also studied at Harvard. Could you please speak to us a little bit about your experience abroad and how that will help you in the work you're going to be carrying out with the committee? Answer. Yes, thank you very much for the question. Indeed, like a number of academics in major Canadian universities, I've had the opportunity to travel and to teach abroad or to attend conferences as well. I think the dimension that's interesting from the committee's point of view is that I have I'm familiar with a number of different cultures outwith of Canada. So I have had this experience working with people from different cultures, and that's something that's very important when we're examining files, to be able to evaluate the contribution that somebody can make to an organisation such as the Senate. This international experience isn't absolutely essential to make me qualified for this position, but that's how I feel it would help. Question. I'm going to be sharing my time with my colleague, but before that, you also worked in private practice for a number of years with Borden Ladner Gravis. Perhaps you could talk to us a little bit about your experience in the private sector as well. Answer. Yes, I did work for Borden Ladner Gravis, but I was an advisory lawyer at the time. I wasn't working with them full time. It was after I'd been working at the Supreme Court. I was hoping to get a better understanding of class action suits, which was out with my area of expertise at the time, and I thought it would be something that would be useful for me to get a better grasp of these class action suits, to spend a few weeks with a large lawyer's office. It gave me the opportunity to work. They gave me the opportunity to work with them on a number of these class action suites. That's what I did for a period of 3 years. But at the same time, I maintained my position at McGill, and I worked at McGill during that period. Question. You're going to be there's going to be several members in this committee. Have you worked with any of the other members before? Answer. With the you're talking about the advisory board, is that correct? Question. Yes, absolutely, that's right. Answer. No, not at all. I don't know any of the other. I didn't know any of them before we started working together a few weeks ago. How is the working relationship? Answer. Well, I'm really very, very proud to be a member of this board, because the people who are on it are really exceptional. You're going to have the opportunity to meet with them. you'll see that there are a number of people that have received the Order of Canada. We have excellent leadership from Ms. Abe, which is absolutely outstanding.
Did you stop that? You.
Yeah.
Well, no, it's peachy that you agree. That's swell, but irrelevant. You just called a point of order, Mr. Chair. That's for us to do when we think the right. It's not for you to start calling points of order.
Mr. Chan, you call that point of order?
Yeah, I'll call that a point.
Okay.
I don't think it's relevant. I don't think it's relevant to the.
Mr. Chair, let's let Mr. Chan and others call the points of order. Let's not have you doing that. You know, I think you're like Larry. I think you're an awesome guy, but you're not being an awesome chair. You're not being impartial at all, and you got to get back to being impartial. That's your job.
I actually was about to say I don't think that last question was actually relevant either. To be fair, I'm calling a point of order on my own side here now because I actually think it goes beyond the mandate of our examination.
Arnold, I believe you believe that, and it may very well be.
I was about to say,
press the button, but you hadn't done it yet, and
yes.
that goes to our chair being impartial at all times, which is not what's happening right now.
Calling a point of order on us.
That's all.
The chair gets to rule on various things, Mr. Reid. Okay, we'll carry on anyways. So, next question, Mr. Graham.
I think I'm ready to pass on to Ms. Ahoda, if she'd like.
Okay. Hello, Professor Juntres. Thank you so much for being with us here today. I'd like to go back to your appointment as amicus curiae to the Supreme Court and the experience. If you could talk about something particular that you learned from that argument and what you bring from that to this appointment on the Independent Advisory Board.
As you know, the reference to the Supreme Court that I participated in was primarily a reference about the amendment process under Part 5 of the Constitution Act, determining the level of provincial support that had to occur under our Constitution in order for certain amendments to the Constitution to be made, particularly amendments that relate to the structure of Senate, all the way to the issue of abolition of the Senate. And so, as I've said in another setting, I think it'd be fair to say that it was more a reference about the constitutional amendment process than a reference about the Senate itself. The Supreme Court was not charged with the mandate or responsibility to assess various proposals for Senate reform, but asked under the reference to determine what processes for amendment needed to take place. So that was really the focus of the work that I did as amicus curiae, focusing on the structure of the Constitutional Act and the provisions for amendment of the Constitution that we are working with. Nonetheless, I think it's fair to say that in understanding the kinds of issues that are likely to arise in that conversation, I had to become quite familiar with the historical record with respect to constitutional amendments on the Senate, and part of that involves obviously consideration of a variety of concerns expressed about the Senate, its current configuration, and possible transformations for the future. So I think it's the thing that I might bring and that might be relevant to an understanding of qualifications of individuals that would be appropriate senators. The understanding that I bring is this understanding that's based on having read very widely on the role of the Senate and on its position within our constitutional architecture.
You have 30 seconds. Finished?
Yeah,
okay.
I'm finished.
Mr. Richards, next questioner.
Thank you, and appreciate you being here with us today. And I know it's sort of conducting, I guess, what's essentially, in some ways, an after-the-fact, I guess, job interview, sort of in public, is probably a fairly awkward situation, and we appreciate you putting yourself through that. So, when obviously we've heard your qualifications, and I think it would, I would be able to speak for everyone in this room that we're quite impressed with the background and experience that you have. One of the things, though, that I always find helpful in assessing someone is what they would do in certain situations. I like to put people through scenarios or situations and what they would do. Obviously, given the fact that this process is already well underway, there is going to be some element, I suppose, where I can't really ask you what would or should you do. It's going to be a little bit of what have you done, because it's already obviously well underway. So there's a couple of different aspects of the job that I see as quite important that I'd like to just kind of get an assessment of your thoughts on. So the first one is we've got sort of two stages to this process, and there's this first stage transitional process, I guess we're calling it, and then there's going to be a transition into a permanent process. Now, obviously, when there's enhancements being made, which is what's been indicated on the Democratic Institutions website, to that process when it becomes permanent, I would assume that in your role on the board, you will have some opportunity to make recommendations or suggestions about what those enhancements would be. So I wonder if you could maybe give some indication as to maybe what some of the flaws or challenges that you've seen in the process that you've been undertaking at this point are, and what you might think would be good changes to be made to that process going forward. It helps us obviously be able to assess your ability to be able to make those kind of suggestions and recommendations.
I think it's a point of order in going to process once again and not actually the competence of the witness or his qualifications.
It's the way they were.
It is. I mean, I should take that word think out. It completely is and does not go to the mandate of the...
You can judge. We've been through this enough today, so you can judge witness to Mr. Jutras. Go ahead.
So I think I'll confine myself to saying that it's probably premature for me to answer that question. The process is still ongoing. There will be, as I said, a report to the Prime Minister under our terms of reference that will assess the process and identify some of the possible improvements, but I don't think I can identify them now, and we haven't had that conversation as a board, and so I think I would prefer to wait until that's done before addressing that particular issue.
Okay, I'll respect that, but you had mentioned, I think, in response to an earlier question, I believe it was from Mr. Reid, that that report about those recommendations would be made public, that the report that you would be giving as a board would be made public, so we will be able to have some idea as to whether the enhancements that the board is suggesting, and we'll know in public. Is that, can we just be confirmed with that then, that you will be making that report public?
So that is my understanding, and indeed I think that is explicit in our terms of reference under Article 13, third paragraph. The report must be made public under those terms of reference.
I appreciate that, thank you. So maybe we'll move to another area that I think is fairly important, and there's this idea of consultations that will take place with various groups in the transitional process. I'll quote from it. They could include groups which represent, and it has a variety of different groups that it could represent, and then indicates that that would be in order to be able to ensure that there's a diverse slate of individuals with a variety of backgrounds and skills and knowledge. And those are brought forward. So what I'm trying to get a sense is, obviously your previous experience undertaking those types of consultations with organizations. And so, again, it's a difficult situation because you have already undertaken some of the process here. So I want to ask a bit about what you would or should do, but in some cases I'm going to be asking, I guess, what you have done because it's already underway. So how have those consultations been undertaken? How should they be undertaken? I'll ask both, I guess. Have groups been approached, or will they, or have they been required to apply? And based on what criteria have and should those groups be chosen? And then how would the board, or has the board interacted with those groups? And then in your view, should those groups that are participating be made public?
Again, Mr. Chair, I'll leave it to the discretion of the witness, but I think Mr. Blake's latter part of his question again drifts back into current process as opposed. I was fine when we were talking about previous experience, and I think that goes to the examination of the competency and qualifications, and I'll leave it to the witness to decide if he wishes to respond.
I mean, obviously, Mr. Chair, it's quite clear. I'm trying to ask what should be done, but obviously the process is underway, and that's a reality. We can't ignore the reality that it's underway. So to ask what should be done, I have to ask what has been done, because it speaks to what's the reality.
Mr. Jutras.
So I don't think I want to answer detailed questions about what should be done for reasons that I outlined in my previous response to you. I think that assessment needs to take place once we're done with this particular transitional phase, and it's too early to address this. And I think it would be preferable, given our terms of reference, if the different interlocutors were addressed in the appropriate sequence. So terms of reference require us to report to the Prime Minister. Prime Minister, I assume, under the terms of reference, will make that report public. And I assume the report, given our terms of reference, the report will highlight every dimension that may be relevant in terms of making recommendations for improvement.
So can I ask you then, how have these groups been approached, or did they have to apply? What criteria that the groups were chosen on, and how the boards interacted with those groups? Can I ask you those questions?
From witness.
Thank you. I think, again, those questions go to process that will be reported on in the document that I've just mentioned, rather than my qualifications. I can say and refer back to what was said by our chair, Huguette Labelle, in her testimony before your committee. The process was a very open one. As you know, the committee set up a website, invited nominations and applications, and I think it would be fairly easy for a person on your committee to identify the different elements that were engaged in by the committee in order to generate nominations from and applications from very eminent Canadians and highly respectable Canadians.
Thank you. Just before going to the next intervener for 5 minutes, Ms. Petitpas-Taylor. Just before you start, though, I just want to say to the committee that, normally being a very flexible person, but I have called every party out of order on this, strictly staying to the standing order that what we're allowed to do, because there's hundreds of orders in council coming up, and some committees look to us as a precedent. So of all committees, we shouldn't be one that's going outside the directions of the standing orders for as much as possible. So, Ms. Petite-Taylor.
Bon matin, Monsieur Jutras. Encore une fois, merci.
Good morning. Once again, thank you very much for appearing before the committee. Your professional competencies are beyond reproach. You've got an excellent CV. Perhaps you could talk a little bit more about your personal experiences in general that will help you with the tasks that have got to be done. Answer. What do you mean by my personal experience in general? Well, you've talked a great deal about your professional achievements, but what personal qualities do you have? Perhaps you could talk about your personal qualities. Could you expand on that a little bit? Your general personal experience. Answer. Well, it's a very difficult question. I don't know if I can give you any sort of intelligent answer, but I'll do my best. I could perhaps say that I'm in a university environment. I'm involved in higher education, and that's close to the heart of my professional life. In my family, I'm of the first generation to go to university. Neither my father nor my mother went to university. My parents believed passionately in education, but they themselves didn't have the opportunity to do that. So personally, I'm just a regular Canadian. I come from a middle-class family. My father was a municipal public servant. My mother was in the school board. I studied in a large high school south of Montreal. It was a regular public school. Then after that, I went to a cégep in Quebec. So in terms of my personal experience, even if people associate me with university and other such institutions. My life before that was really just like any other Canadian in the middle class. I really don't know if I can say any more about that. I really don't think it's that interesting. My life, to me, it doesn't seem hugely relevant to my mandate and to the committee. Thank you very much. Well, perhaps one last question. What qualities do you think that you have that really will be essential for fulfilling your mandate? Answer. As I was saying earlier, I think the ability to evaluate questions effectively, because there's a huge amount of work to be done here, my ability to read CVs, to evaluate them, my capacity to look at these documents and cut to the chase, get the essential information out. It's difficult for people to try and sum up their lives in a document and then hand it over to a board for it to be evaluated. It's a bit like what we're doing here today. You have my CV, it's over 4 or 5 pages, and you're trying to get an understanding of who I am, and you're trying to work out what skills I have. So I have considerable experience in looking at people's CVs and getting to the heart of the information. But more fundamentally, and what I was saying earlier, my fundamental qualities are that I have a strong reputation for personal integrity. I don't think anyone would question that. I've got good judgment. I'm able to work in a non-partisan, independent fashion, and I have a solid understanding, a very good understanding of the Canadian Constitution and the Senate to make sure that people will be able to fulfill their tasks. Thank you.
Mr. Jamie Schmale.
Thank you very much, Mr. Chair, and thank you for taking our questions today, Professor. We do appreciate that. I only have a few minutes, so I will be quick, and it's unfortunate we can't talk about the process, because I think with that underway, it's very important to get some answers on this. We can't talk about accountability, so let's talk about the current makeup of the Senate and using your experience. You look around that room of the current senators, you have all different backgrounds. How, looking at the mandate letter, and what in the terms what you're looking for. I'd like to say, education is very important, but it's not everything. But I see a lot of it is weighed towards the education part. I have a lot of business people in my writing that are very successful and have a lot of common sense. How are you using your experience going to ensure that just not from the academic side, but you're also getting people from other fields that have, I would say, a lot of common sense, but not a heck of a lot of letters after their name?
Again, I think that goes primarily to the criteria that we were asked to use, and not necessarily to my own qualifications. So I'm going to refer you back to the annex that was provided by the Minister on qualifications and merit-based assessment criteria. I think they're well-defined, and they're not all focused on letters after people's name. I think there's a very broad range of merit-based qualifications that the committee is required to assess. And again, I go back to what I said to your colleague a few moments ago. The exercise that we're engaged in requires the ability to make judgment about individuals. It's not that different from the one you're engaged in right now, making an assessment of my own qualifications and competence. And I assume that not everybody in the room over there is a person with numerous degrees. There must be a wide range of qualifications around your table, and I'm absolutely convinced that your committee is well equipped to make an assessment of my own qualifications. So I would say the same of my own competence to make that assessment.
Thank you, Professor. That also goes back to democracy and how we are elected. We're based on our constituencies and people making that decision on whether or not we are qualified. So that's why I ask you, I don't want this to be a Senate of elites. I want to see a wide range of backgrounds. And like I said, if you're one of the main things that we keep going back, and we heard it yesterday at the Senate committee, was about education. How do we ensure there is, in your experience and your background, ensuring there is I'll use it, accountability, and also that you are representative of all aspects of Canada, including those that may be successful in business but may not have a huge amount of degrees.
I think what I want to say on this is that obviously you're interviewing me, but there's a large committee that is addressing this. We have 3 committees, as you know, provincially constituted, committees of 5, and there's a very broad range of expertise and competence on this very fine group of people. And so obviously I'm one person. I have a particular profile, and that profile is not replicated in the other members' career, and everyone brings to the table something enormously valuable in making exactly the assessment that you've just identified.
Out of time?
No, you got a minute and 15 seconds.
Okay, perfect. Thank you very much. And, we talk about being a new nonpartisan Senate, which I think is very difficult to happen because in any group, whether you're a minor hockey association, a chamber of commerce, you always, migrate toward people with similar trains of thought. Using your experience and looking at all these CVs and letters of recommendation, the minister said yesterday, political experience will not necessarily disqualify you from being a candidate, but how are you, using your experience, going to ensure that they actually stay nonpartisan after the fact?
Frankly, what happens after the fact is not something that the board can control, so I'm not sure I can answer that particular question. What we're trying to do based on our own qualifications is make an appropriate assessment of the ways in which the individuals who have applied for this, and there's extraordinary Canadians of all walks of life who've applied for this position, I can assure you, and make sure that these people meet the criteria that have been provided to us as the criteria, the merit-based assessment criteria that we must work with in making recommendations to the Prime Minister. That's the only thing I can say, right? All of us are committed to maintaining the terms or to abiding by the terms of reference, and to doing this work very seriously, I think requires, and it requires each of us to step outside of ourselves for a minute and think more broadly about those qualifications.
Next questioner is Mr. Arnold Chan.
Thank you, Dean Drutas, for appearing before this committee. I wanted to simply also reiterate what many of my colleagues around this table have indicated, that we are incredibly impressed, and thank you for putting yourself forward in public service in advancing this particular process that we are constitutionally bound to do. I want to get back to some of your opening comments with respect to your experience, Dean, particularly as it relates to your experience in constitutional law. I do note that you did put on the record that this is not necessarily your core competence, core professional competence, that you focus more on civil procedure and on law of contracts. So I do want to explore your, in particular, your experience in the area of constitutional law. I recall in your opening remarks that you had indicated that this was a focus of your graduate work at the Harvard Law School, and I note that you are a recipient of the Frank Knox Scholarship, a very prestigious scholarship. I think my brother has one. And I wanted to know a little bit more specifically about some of the research that you did and how that might inform you in terms of the work that you're doing now before this committee. Before this advisory board.
Okay, so very briefly, my graduate studies at Harvard were 30 years ago, a little over 30 years ago. The focus, as you can imagine back then, in constitutional matters was the Canadian Charter of Rights and Freedoms. These were the mid-1980s, and everybody with an interest in public law was particularly focused on human rights and constitutional guarantees for civil liberties, and that was the focus of my studies back then. I wrote my master's thesis at Harvard on the scope of Section 1 of the Canadian Charter of Rights and Freedoms and the possible interpretations of limitations to rights as flowing from Section 1. I should say that this piece was written well before the Supreme Court's jurisprudence evolved on Section 1 and has become obsolete 30 years after the fact. After this, I really kept my focus on private law for the longest time, I think, until I went to the Supreme Court as Executive Legal Officer of the Supreme Court of Canada, where I had opportunity to work on constitutional matters, both in relation to charter issues and in relation to division of powers and institutional aspects of the Constitution. And since that time have kept my interest in this area and read widely in this area, even though I don't now publish in the area or engage in research in this area.
Thank you, Dean. Thank you, Dan. I wanted to then perhaps look a little bit about your additional experience. You noted that you had been the principal investigator where you've written there was an anonymous research grant where you looked at rule of law in Russia. Did that particular type of work, did that get to the issue potentially of division of powers or help inform you in terms of dealing with bicameral parliaments or constitutional or the drafting of constitutional processes or the like?
No, that work that we did, this is a group of McGill professors who are engaged in this effort, and the work that we did had to do with judicial structures, administration of justice issues, and also on corruption aspects or corruption controls that one might imagine for a federation like Russia. So no, the focus was not on division of powers or bicameral governance at all.
I myself might be straying into something that is out of order, but I'm going to ask, based on your understanding, obviously, as a lawyer and as a professor, would the decisions of the Independent Advisory Board for Senate appointments be binding on the Prime Minister and the Executive Council?
Sorry.
So,
and I know that may be a procedural question.
Procedural question.
Okay, I withdraw the question.
We're past noon, but if the witness would beg our, we had a few points ordered, took up some time, and we have one round left of 3 minutes. If did you want to ask any questions, Mr. Christofferson?
Oh, absolutely. Absolutely. We'll give it a second shot. I'd just like to remind our witness that the chair, his chair, answered all my questions. She had no problem. She didn't try to hide behind anything. She just answered as best she could, and I accepted that. That's all I was looking for. So I want to come back again. I want to try the same kind of question on a different matter, because the chair will rule me out of order if I don't. And that is the issue of the primacy of the House of Commons. Now, under the Constitution, which you're an expert, know more about it than most of us, there are certain rights that are bestowed in each houses. The current practice has been since 1867 that the Senate, with very, very few exceptions, is very careful not to thwart the will of the elected chamber, recognizing in deference to the fact that we are elected and have that mandate. Now, we did have a circumstance where Jack Layton, former leader of the NDP, brought forward his Environmental Bill of Rights, which I believe passed the House of Commons twice. It was sent to the Senate, and without any debate, they killed it. So my question to you would be, when you're interviewing someone, what are you looking for from them in terms of how they see the division of power between the House and the Senate? And would you be wanting to hear that they would exercise a deference to the elected House, or would you be looking to hear from someone who says, no, if I'm appointed, I will exercise every single constitutional right that a senator has?
I think this is, again, a question that goes to process and a question that goes to the qualifications of individuals who will be appointed as senators rather than qualifications of members. But let me try to answer it that way. The mandate of I'm sorry if I'm making you unhappy with my answers. I'm doing my best to address them within the mandate of the committee on which you sit. Let me say this. The criteria that have been provided to us, the criteria that we work with, require us to assess very carefully the ways in which which people meet the basic knowledge qualifications. And I would say those knowledge qualifications include not just the written mandate of the Senate, but also a sound understanding of its place in the constitutional order of Canada. And I think one would expect that that gets manifested in the ways in which people describe their own profile, their own career, and their own expectations of the contributions that they might make in Senate if they were selected.
3 seconds.
3 seconds. Just another question. When you were doing your research, which was very impressive, did you do some research into the question of accountability and how senators should be more accountable? And did you study the aspect of a deference to the House of Commons and out of respect to the Canadian people who voted for the House of Commons? Did you research that? Sure.
So this, as I said at the outset, this is not an area of scholarship for me. I have not published on the Senate. Indeed, I don't think you will find anything under my signature that would address the kinds of questions that you're raising. That being said, I'm quite familiar with the concerns that you expressed because those figure prominently in all of the scholarship that I was reading in preparation for my work as amicus curiae before the Supreme Court of Canada in the Senate reference. So I'm quite familiar with those questions indeed, although I have not published in them.
Thank you.
Could I just
Yeah.
no more questions. My time is up. I just want to say though, I find it like totally unacceptable. You sense my frustration. It's not acceptable for you to say that's what we're going to look for in the candidates. You're the one that is replacing the Canadian people's judgment, and you're deciding whether they've got the qualifications or not. And your refusal to tell
Mr.
me
Chair,
what template you're going to use.
I think Mr.
further
Christopherson
makes a
is clearly
mockery
out of
unelected a Senate. Thank
I
you,
have a
Chair.
point of order. Clearly, I think we should thank the witness. If Mr. Christopherson wants to continue this conversation with the committee after the witness has been dismissed, I'm willing to entertain him ad nauseum. But again, I think I think we're done.
I'd like to thank the witness for coming. You're one of our first ones on this, and we certainly appreciate your qualifications and taking the time today to answer questions. And good luck in your work. And we'll just
Thank you very much.
suspend while we change the chair and committee replacements, and then go on to committee business.
Okay, so we'll call the meeting back to order. We are still televised and in public, of course. So we have a couple of motions to deal with. Now, I will point out that the clerk does have a budget for the one brief study. I think it's in relation to the advisory board. So we've had a couple of meetings and one more that is planned, which my intention is to maybe we would do is just quickly move in camera at the very tail end of the meeting with just a few minutes to go, and we can deal with the budget. I think it can be dealt with fairly expeditiously. So that would be my intention, unless the committee would like to direct me otherwise. We just go quickly in camera to deal with the budget, so that we can do that, and we'd do that just 5 or 6 minutes before the end of the meeting, and make sure that we're finished right on time. I know that being over here, other members have other meetings to get at, and we would have to try to make sure we wrap up right on time. But having said that, just letting you all know what I expect to do and when. But we do have a motion that has been put before the committee. There's been some amendments that have been suggested, and then the debate was, when we were last on it, was on those amendments. You've all been all received. It's been just passed around. The track changes that show the amendments that have been proposed, and I would entertain a speakers list on that debate. Yes.
Thank you. I had a motion as well that I wanted to introduce relating to today's subject matter. I'm hoping that the mover of the motion, Mr. Christofferson, will indulge me in suggesting that I move this motion first. I can't imagine that it would not be a matter of consensus and easily dealt with, and it relates, of course, to bringing back the witnesses to deal with the substance that was not permissible under the standing order governing our meeting today, specifically Standing Order 111 sub 2.
Okay, so you have a motion you'd like to move. I can add you as my first speaker, and if you'd like to move the motion, you're more than able to do that. If you could, if the clerk has asked that if you do, you could read that slowly for us so that we can make sure we get it recorded.
Certainly, and then I'll actually give you the text of the motion as I've written it out.
Okay. Thank you.
Thank you. So I guess the answer is I'd like to be first in the speakers list, and now, taking advantage of that, the motion is as follows: whereas members of the Senate Advisory Board have been, by reason of a provision of Standing Order 111 sub 2, being unable to answer questions relating to the administration of their responsibilities, moved that the permanent members of the advisory board, that is to distinguish them from the provincial members, be invited to appear before the committee before the end of March 2016 to answer all questions relating to their mandate and responsibilities.
Thank you, Mr. Reid. That motion has been received. Okay, so that has been duly received, and we can proceed to a debate on that motion if that's Mr. Christofferson's wish, because otherwise we would have to forgo yours.
Chair, I'm fine deferring my motion to allow this motion to come before it, and then we'll jump back to my motion.
Okay, so then I would entertain speakers on this motion. I see Mr. Christofferson.
Is Mr. Reid going to speak to his motion? Or have you, if you have?
I kind of did, I think, in the course of editorializing during Mr. Choutran's presentation.
Yeah, that was my understanding that he had, and obviously he has the right to speak again if he chooses, but you are first on my list and followed by Mr.
I appreciate
Chan.
that, and I don't intend to be too long, but you know what the Senate does to me. I got to tell you, if you notice, I didn't have the same problem at the first meeting I did with this one. At the first meeting, I asked, I believe, similar questions. I deliberately structured them in a way that I believed would get past the censorship of the government and pass muster with the chair, and that held in the last time. So I can't see that my thinking was that far off. And the chair, who has a lot more to be worried about than any of the members, answered quite quickly, openly, and I would have liked, it's not necessarily what I wanted to hear, But she didn't make any attempt to not answer the question. I mean, I have to tell you, and I don't want to cast aspersions against the previous witness. It sounds like an amazing academic and has made a wonderful contribution. But I got to tell you, it almost sounds like he was coached. Either that or he spends as much time keeping an eye on politics as he does academia, because those were political moves. And most people don't normally have that at their fingertips. But anyway, that's an observation, not an accusation. And I just leave that there. But to the substance of it, it was very it's frustrating for those of us that it drives us insane that there are lawmakers chosen by the Prime Minister rather than the Canadian people. We forever have senators pointing to their good deeds and the good reports they have, and of course the response is, we can have all the good deed blue ribbon committees that we want, but what you don't do is make them lawmakers. That's the point. And in fact, I remind colleagues that the vote of a senator is worth more than ours because there's fewer of them. So it takes less votes to win the second chamber than it does our chamber. So anything that involves appointing them deserves a lot of serious scrutiny. And I don't think that I would, in fact, I didn't attempt to play any games. I don't think I left the impression that I was playing any games. The last witness we had, it was very straightforward. I did my thing. Time was up. I shut up and we moved on. This time, I had a witness on an issue very close to my heart, who is only one of a handful of people that replaces all 35 million Canadians in deciding who our lawmakers are, and the witness wouldn't give me a straight answer. Like, at least answer it. And being a lawyer, I'm surprised he made a bigger deal out of why he didn't want to answer it, rather than giving a good lawyerly answer that didn't give me an answer. Goodness knows we watch Question Period. Professionals do it every day. I'm as guilty. I did it in my time when I was a minister. You know, the better you are at not answering questions without it looking like that, the more successful you are in Question Period. So I'm fully prepared to accept that as a way to deal with the question. But to start playing games on a question of, was it right or wrong what the Senate did to Jack Layton's bill that came from, whether you like Jack Layton or the bill or not, it came from the House of Commons. The Senate rejected it without even a debate. And I think it's fair for me to ask somebody who's going to be doing the hiring of senators, not the electing, the hiring of senators, to ask them what they would think of a witness in response to that question. Do they think it's acceptable? Would they be looking for a candidate, an applicant, who said, well, I find that fine. Constitutionally, they have that right and there's no problem. Or would they be looking for somebody to say, you know what, I think that really crosses the line between, yeah, it's our legal mandate, but there is that deference to the House in recognition that they have the legitimacy of a mandate from the Canadian people. And as flawed as that is, it's the best we've got. And they don't have that. They do not have the legitimacy of being elected. We could be the worst MPs in the world, but we've got the legitimacy. And I remind you that Canadians can fire us at the end of 4 years. We have a small group of people that are hiring senators that we have to live with for decades because you can't fire them. So I will end where I began. I had no interest in playing games with this. You'll know, ask Mel, you'll know when I'm playing games with something, it's as obvious as hell. And I say so right up. I try to anyway. I wasn't. And that wasn't my intent. And I'm incredibly disappointed that we got answers of avoidance from somebody who's going to play such a critical role in our beloved democracy. And that's why I'm going to support this motion, because I want an opportunity to see if they're all going to do that, because the chair didn't. If anybody was going to play games, it would have been the chair, setting the precedent. I'm not letting any questions come near here. We're going to stay this narrow. No, she was very open-minded. She understood where I was coming from. Didn't give me the answers that I was hoping to hear, but attempted to answer my question, and I thought as fulsome a way as she could, recognizing, you know, where she was coming from. As you recall, I did not I don't recall. I stand to be corrected, but I don't believe that I went after that witness in any kind of redirect in a serious way, maybe for clarification, but not the way I was today. I was very disappointed and borderline angry that someone who has the role that they've been given to play in our society, and whether they like me or my politics or not doesn't matter, as long as my question gets through the chair, it's a legitimate question on behalf of Canadians and deserves to be answered as best as possible, not to have someone use their scholarly skills to try to avoid answering the questions. That's what we do. They're doing our job when they do that. We play those kind of games. There shouldn't be those kind of games there. And so I'll end it there. I'm not going to turn this into a filibuster, but I am going to just underscore how things shifted for me today and how I am now 100% behind the Conservatives in wanting to pull in as many people and look in every corner, because the way the government is playing this, I know in their heart of hearts they know this is bull. They got to do what they got to do. But I'm telling you, when we got witnesses on a subject like this that come in and start answering questions like that from someone who is trying to be fair-minded, then we're going to have trouble. And my way of helping with that trouble is to support this motion. Thank you, Chair.
Okay, thank you, Mr. Christopherson. And maybe just quickly before we move to our next speaker, Mr. Chan, I will just read the motion back. There's been a couple of requests for that. So we've got it finalized here, and I'll read that very slowly. I will, yeah. So it's that the federal members of the Independent Advisory Board for Senate Appointments be invited to appear before the committee before the end of March 2016 to answer all questions relating to their mandate and responsibilities. So I'll give members a couple of seconds to catch up there, and then whenever you're ready, Mr. Chan, the floor is yours.
Thank you, Mr. Chair, for ceding me the floor. I'm going to start with the comments from Mr. Christopherson. And I'm going to put on the record that actually, to some degree, I regret giving you as much discretion and the members of the opposition as much discretion on the line of questioning that you had with respect to Madam LaBelle. No, I mean, as I said, I could have objected at the time, and I chose not to at the time. And so, at the end of the day, we are prescribed, and this is the point I want to make, Mr. Christopherson, we are prescribed by the current standing orders with respect to the conduct that this committee can do with respect to examining the qualifications and competency of a prospective appointee. These are not standing orders that I made up. These are standing orders that are the current rules of procedure that govern what this committee can do. So I simply want to put that on the record, is that if we stick within the confines of the standing orders that all of us inherit, if you don't like it, Mr. Christopherson, you have a right, okay, to subsequently propose as we go through our processes of reviewing our standing orders to make changes appropriately. But at the present time, my point is that we are simply conducting the business that we are prescribed to do under the current standing orders. So now, with respect to the substantive motion that has been put forth by Mr. Reid, my personal view at the end of the day is that the questions that you are ultimately concerned about, the government is more than transparent in granting you the opportunity to have the minister and his officials appear before this committee on March the 10th to answer those particular questions. And as a result, from my perspective, we will not be supporting, at least I certainly will not be supporting this particular motion. You can ask any question you like at that time of the minister and her officials with respect to your concerns about the process. But at this time, we are only charged with dealing with competency and qualifications. That is our mandate, and as a result, we will not, at least I certainly will not be supporting the motion.
Mr. Christopherson? Yeah. Actually, there is no other speakers, so you're...
I want to ask...
Oh, sorry. Okay.
That's fine.
Then Mr. Reid and then Mr. Christopherson, you'll be next.
Thank you, Mr. Chair. Yeah, so I just wanted to say, with regard, because I wanted to respond to Mr. Chan's comment, with regard to the last point he said, looking at the qualifications is our mandate. That is our mandate, he said. And under the terms of Section or Standing Order 111, subsection 2, which was governing our meeting today, that is correct. But that's why in the preamble is not part of the formal motion, but I read it out to you, and the point was that, of course, that governed us and that restricted us today. But given the fact that these are germane and important questions, having another meeting at which we deal with these questions would be a time at which we could deal with those things. So we are not, by the nature of this committee, by the nature of our mandate, I mean, there's some things we ought not to be looking at. We should not be asking about, international human rights questions, defense questions, questions relating to status of women or the Library of Parliament. Those things are outside our mandate. But the actions of people like the members of the advisory boards are very much under our mandate. How we choose to deal with this is the subject of any individual motion we bring forward. And so this new motion would allow us to fill in the lacunae that were left by the nature of the original motion. And I have to say, going back to it, had I realized such restrictions would be in existence under the original motion, I would have raised these objections at the time and sought to broaden our mandate, because I could have told you from the start that I actually thought the members of the advisory committee whose CVs were posted online were impressive. So the questions regarding their qualifications were, quite frankly, unnecessary. I didn't doubt their qualifications or their objectivity. But I do have questions about their mandate. Of course, they have a system for reporting to the Prime Minister, but it is not unreasonable for us to want to get separate information about this. And I want to stress this because I think it's an important distinction that might be lost on a casual observer here. The fact that someone has a mandate to report to the Prime Minister does not mean that they are exempted from a mandate to report to us. That is a general mandate. The Prime Minister is, at least in theory, an agent of the Crown, and that is distinct from the House of Commons. So reporting to the House of Commons is something that is not exhausted by the fact that some form of mechanism exists for reporting to the Prime Minister, an expectation that you report back to the House of Commons, and indeed to the Senate, should they choose to conduct any hearings of their own and invite in these individuals. That none of that's exempted. That is a reasonable thing to ask for. And that brings me around to Mr. Chan's initial comment, which was that we're letting you speak to the minister. I have to say that was an odd way of phrasing it, but I don't want to fault him for that. We have a right to question the minister. She is coming here at a time and a place that is frankly inconvenient from our point of view. She should have been here earlier. Inconvenient, I should use that advisedly. I don't mean, it's untimely. She should have been here earlier. The Liberal members insisted on writing in to our invitation that she come at a time that fits with her schedule. Well, frankly, that's the way these things are always written, right? That's the way they're always written. Or actually, it's implicit. If a minister doesn't want to come, we can't force them. So maybe we should be grateful. Maybe we should be, I don't know, kissing somebody's ring in gratitude for having been allowed to summon a witness before this committee. But I don't think that is what is conventionally understood. That is what the public understands to be the case here. I don't think the public believes that the ministers are responsible to the Crown and the House of Commons represents the peasantry waiting outside who may or may not be permitted by the grandees to ask deferential questions, to humbly beseech a minister of the Crown for a question. I think quite the contrary. And I know the minister, who I actually like a lot. I kind of think she likes me too. She gave me her little pink flower yesterday because I forgot to wear a pink shirt. That's pretty cool. Was that cool? Yeah. Yeah. So
That's respect. That's respect.
it's kind of cool. Anyway, I'm kind of glad I got put on the record. Like that was a nice thing she did. I appreciated that. So I think she doesn't view things this way necessarily. But look, the important thing is this: the way their mandate is written, they're reporting to the Minister of Democratic Institutions. They're reporting to the Prime Minister. And I anticipate when she comes here, the Minister may well say that I can't answer this question or that question. That is not in my remit. That's not in my mandate letter. That is a separate mandate given by means of an order in council from the Crown to these individuals. Because not only ministers of the Crown are commissioned by the Crown, so are many other people. So is every military officer. So is every commissioner, every head of every board. Everybody who isn't commissioned by the House of Commons and Senate is commissioned by the Crown. That is most people who are out there. Those thousands and thousands of people working for the government of Canada, and they aren't answerable to her. So. And indeed, I think she would make a point of saying, they aren't answerable to me, they're supposed to be independent. The word independent is actually written into their mandate, or written into their title, or at least it's written into all the talking points about their title and their mandate, and therefore I can't answer. So what do we do then? Then we go back again and beg and plead with Mr. Chan to, I guess, kiss his ring and say, could we please humbly beseech you and the ministers, or whoever, to come back and talk here and speak to us. What we want, what I want, and I think I may be speaking for some others here, is to have these individuals come back because they do have a mandate and they're the only ones who can speak to their mandate. And while I respect Professor Jutras' discretion in choosing not to answer certain things certain ways, it seemed clear to me that what he was saying is, I am attempting, although it wasn't really his responsibility to be this, but I am attempting to be respectful of your mandate. In fact, he actually worded things to say that. He said exactly that. The mandate of your letter, or of the standing order under which you've convened this meeting. So now we would have a different meeting at which we would deal with all aspects of his mandate, his performance of his mandate, likewise for the other two permanent members. And that would include questions such as the one that I raised before I was shut down by the chair, which was, how many applications did you actually get? I mean, how many nominations did you get? And there are a series of things they can't answer. It's not their fault, that any filled out application or nomination form becomes a level B protected document. So they really can't talk about that. That is why it's written in there. That's a secret that freezes them from saying anything on the nominal basis that harm would be done if the content of those letters was revealed. So of course we would respect that. But what we'd be asking about is whether, how many actual nominations did you get? I'm interested in knowing that. And I'm interested in knowing that because look at how this process was set up. This process was set up through an announcement, a press release on January the 29th, 2016, that we would now be accepting Phase 1 nominations. And the whole process was announced at that time, a process which up to then was a complete secret. We knew nothing about this. And a process, I should add, that was designed by the government and not by the advisory boards. That's just to lay the blame where the blame ought to be laid for this. So the Phase 1 process was set up on, or when it was set up, it was announced to the public on January the 29th, 2016. And we were told that nominations would be open until February the 15th, 2016, right? So that is, you can add it up, that is 15 days, at noon. So 15 days if you count the 15th. And if you count the 29th, it was at 6 p.m. on the 20th. You can check the date on the email where this was sent out. The 29th is a Friday, so Saturday and Sunday were weekends. This information was not posted in the normal spots where you'd expect to see it. It wasn't, for example, on the Minister of Democratic Institutions website. So knowledge that this process was in existence took a while to spread out. Like, I didn't find out about it until I got an email from the minister. Dennis, when was that? Tuesday?
It was on the Monday.
When, it was on the Monday? Okay, so afterwards, after a weekend had gone by. You can't get appointed under this process. You can't get, your name cannot be passed on to the Prime Minister by the advisory board unless A, you've submitted your application, and B, if this brand new nomination that nobody knew would exist isn't filled out by an organization, or more accurately, by an officer of an organization. Someone fills it out and then says, I'm from whatever the organization is, my title is president, vice president, chairman of the board, or whatever else that happens to be. Now, I'm involved in a number of charitable organizations. This very Saturday, I will be chairing, as I do every year, the annual cystic fibrosis fundraising dinner in Ottawa. I volunteer at an organization, a community kitchen called The Table, and host a fundraising dinner for them at my house every year, and so on. And that's not because I'm special or important. It's just because that's what happens when you're a member of Parliament and been around for a long time. But I do know a little bit about how organizations work. So let's say, for the sake of argument, that one of those two organizations had wanted to put forward the name of somebody, and they wanted to be responsible about it. Well, what they would have to do is send out notice of a meeting. They would use their rules of order, and everybody uses different rules of order, but I submit that it might be Robert's Rules of Order. Those are the most commonly used rules of order, and others are very similar with regard to notice requirements for board of director meetings. It would normally take 2 weeks to summon a board of directors meeting. Now, on the assumption that they didn't learn about this till Monday, and that would be extraordinary if they did learn about it. Why would they learn about it? Do you think that the Cystic Fibrosis Foundation or any other organization like this spends its time hunting through the various outlets through which these notices are put out? No, of course they don't. So they might not find out about it immediately. You call your meeting. So January 29th, 30th, 31st is Sunday, February 1st is Monday, right? We have to call a meeting. We have a 2-week notice requirement. When would that be? Well, 2 weeks from February the 1st, that would be February the 14th, which is a Sunday. February the 15th at noon is your deadline. So we could have I guess if we had an extraordinary meeting on the weekend, we could pull this off and then submit it on Family Day. But in all fairness, it's not Family Day in every province, but it is in Ontario. And one of the vacancies is in Ontario. And I actually don't know whether it's Family Day in Manitoba and Quebec. I'm just not up on their provincial holidays. It's one of those areas that I haven't researched perhaps as well as I should. But there you are. So it would be literally impossible to appoint or nominate somebody on the advice of the board of most organizations. Literally impossible. Now, it's practically impossible for virtually everybody. On the other hand, if you're just submitting that so-and-so who's an officer of an organization nominates someone, supposedly on behalf of that organization, because that is the cover story, it's on behalf of the organization, then that person's name could go forward. So why the tight, preposterously tight deadline? Why the lack of notification? Something normally we would have every time something minor is announced by this government, supposedly a step forward in terms of democracy or consultation. My goodness, there's a national press release and they're thumping it, and it's an epoch-making era in Canadian democracy, but nothing on this. Nothing on this, except this press release, which was not followed by a press conference, not put on the normal websites, nothing. And perhaps you can see why I want to know the number of actual nominations that were made. I'm interested in the number of applications too, but the number of nominations, I can see that. Because my guess, I could be wrong here, my guess is it was really, really small. In Quebec, where you actually have to be representing a district of the province, the 24 districts of the Senate, must be tiny. How tiny? I don't know, but it must be tiny. So let's say, for the sake of argument, you were trying to design a system that was ostensibly open, that was ostensibly about inclusion, ostensibly about removing the Prime Minister's control, which he had under the traditional system. The Prime Minister advises, by convention, advises the Governor General as to who should be elevated to the Senate, and by convention, the Governor General always takes the Prime Minister's advice. Okay. So we're saying, the government is saying that is a thing of the past here. We're doing things differently now. You submit your application, a board decides they submit it to the Prime Minister. He chooses or doesn't choose, as he may see fit. But we want to have him choosing someone who's on the list as a way of showing our purity in this matter. And we only get a couple of names. In fact, they only have enough names to make 4 or 5 submissions. The people who are on there would likely include those who knew in advance this would be the system, those who were informed in advance. Now, those who knew in advance would therefore have, well, first of all, this would make a farce of the system. It was certain people were notified. As tight a restriction as possible was placed upon the process to ensure that very few applications would occur. This would ensure that the names of the people the Prime Minister wanted are now going forward, are guaranteed to go forward. In phase 1, I'm not saying this is true of the later phases. I'm saying this is true of phase 1 because of that ridiculously tight timeline and the novel innovation of the requirement for a nomination. Any organization that knew could have dealt with this in advance. Did the organizations know? Well, in all fairness, the members of the advisory board won't know that, and probably the minister won't either. But it is reasonable to guess that that is the case, that some organizations have indeed known this will be happening. Some individuals knew this will be happening, and they knew to make their application and to have the nomination submitted at the same time. Indeed, Mr. Chair, I will submit to you that it is beyond the realm of credible belief that you could have a situation in which the applicant and the nominating organization would not have known of each other and would not have been working in tandem. Can we imagine a situation plausibly where that would be occurring? I certainly can't. Now, they know, and possibly they have been tipped off by the government ahead of time that they should be doing something. All of which we can't ever know because we are not allowed to summon either the board members or the minister will say it's outside of my mandate. And so these individuals who are on the government's actual shortlist get rushed through. I mean, if it's not plausible to believe that this is true in Ontario or Manitoba, think how implausible it is to believe that there wouldn't have been coordination in Quebec, where you actually have to be the owner of real estate in a specific senatorial election district, one of the old electoral districts of the province of Lower Canada, way back before Confederation. And some of these districts, this is actually a real practical problem. It's hard to find available real estate because these are districts that have very tiny populations. Now they were once populous and the land is being consolidated over time. This is just beyond the realm of plausible belief. So the argument to be made here is this. It may very well be the case when you've got the government working closely in tandem, not with the applicant, that's fine, but closely. It may not be fine when you're pretending you weren't working with them, but it's fine constitutionally. Constitutionally, however, it is problematic when you have a situation in which the nominating body or organization, or if it's just an individual from that organization, it's president, chairman, whatever, and we can't find out whether that was done. Indeed, I'm not sure the advisory board is empowered to make further inquiries and find out. I don't know. As to whether that person was speaking on behalf of the whole organization. Was there a vote taken? Was there a was there a meeting of their board of directors? We don't know. We can't know. Maybe the advisory board doesn't know. It can't know, although I would like to ask that question. That nominee, that applicant, is not in practice subject to a tremendous amount of limitation on his or her independence. They had to compromise their independence in advance in order to get that name into the process. And maybe that's not true with someone who somehow managed to get in under the wire, discovering about this at the last minute. Maybe that's not true. But it has to be true of the people who were pre-selected by the government, as most certainly some individuals were. Now, we can't ask about this here if Mr. Chan and his colleagues shut down our ability to bring back these advisory board members. And if the minister says, I don't know, and she probably won't know, it is outside of the Senate's ethics rules, as I understand it, to raise questions like this. So we can have individuals whose independence is being compromised. And the Supreme Court has been very specific in its, and indeed you heard Professor Jutras say some of this in his testimony today. The Supreme Court has been very specific in saying that senators must be independent, that it is a requirement that senators be independent. A term which is not found in the Constitution Act, 1867, but which is, as the court said, implicit in its architecture. They must be independent. This could very well be a compromise to their independence, and a compromise to their independence which is, through the nature of the process, kept secret from everybody. So we can't know how they've been compromised, how their independence has been compromised. That is a harm. That is an irreparable harm. That is why I wanted to get the minister here before, rather than after, the point at which these appointments are made. And why did I ask Mr. Jutras, Professor Jutras, how long it will take? I did it because I wanted to make sure that we'd find out. Minister LeBlanc said yesterday they're taking a little bit longer than we thought. So there may be time to ask them if this is a problem before it's too late and they've had to submit the names. Perhaps this is why they're taking their time submitting their names. They've got stuck with a situation in which they don't think the candidates that are being presented to them are the right kind of candidates. I'm not sure how they would express that because I understand their requirement for discretion. But it may very well be something else in their mind. I don't fault them. I wouldn't fault them if they didn't answer a question like that because that really would be a lapse in their discretion. But that implies the rules that were designed for them are inappropriate, certainly when it comes to the first time around. And finally, he said we will be submitting a letter to the Prime Minister, or a report to the Prime Minister, which will be public. But it is, while it's reasonable for him to say, I don't want to start making independent comments, I want to discuss this, I think he meant to say this, discuss this with my colleagues, the other commissioners first. That's a reasonable position, I think. It is not unreasonable for them to know that we would like to be asking them questions like that. And if they're all present, they could share something with us. It is not unreasonable for us to want to find out, rather than deferring to our betters and waiting for Justin Trudeau and his imperial awesomeness to look at this, see first, and then let us peasants know what is permissible for us to know. We can all tug our forelocks and thank him for the privilege and kiss the buckle of his shoe. That is not reasonable. That's all I had to say. I'm not trying to filibuster on this. I would actually like a vote today, Mr. Chair, in part because we are going to be away for a week, and I don't want this motion to wait until then to be decided.
Okay. Thank you. Well, we have about 5 minutes before I'll have to suspend and move us in camera to deal with the budget. But I do have two speakers. If they can both be brief, we may be able to have a vote on your motion. Mr. Christopherson and Mr. Chan. Mr. Christopherson, you're first.
Thank you. It was good that Mr. Reid did that and said that he wanted that vote today because I was getting ready to settle in. So I'm glad you gave me an early cue that your preference would be a vote, and that's fine. I'm okay with that. A couple of things then. First of all, I'll take this opportunity to remind the government that I'm the one that went out on a limb when you put forward your clause that the minister would come in as her schedule permits. And I raised the initial concern that that's what governments do when they want to have the flexibility to not have the minister come in a timely fashion. And, the government member, and I believe they were sincere, but they were ever so sincere that, we wouldn't, are you kidding? We would never do that. And so I supported it, if you recall. I supported the motion, said I'm going to trust them. Well, Chair, look where my trust got me. We're still now working on dates. I think we finally have one, but it's well after why the motion was moved in the first place. So I just wanted to mention that for the history. And secondly, I want to ask Mr. Chan, through you, Chair, because my feeling was that the witness today really was almost pleading the Canadian equivalent of the U.S. Fifth Amendment in terms of not wanting to incriminate himself. I want to ask Mr. Chan where he sees the problem in asking somebody on that panel in terms of their competency, why is it a problem to ask them how they view candidates? How is that not competency? Competency is the ability to do the job. Qualifications, nobody's questioning. Qualifications of all the candidates have been like stellar, like dizzying. So many letters after their names. They're truly impressive. I grant that to the government. But on the question of competency, competency speaks to the ability of the individual in terms of how they see and do things. And so I'd like to know why it would be unacceptable to the government to be asking a question of someone under the rubric of competency, how they feel about, for instance, accountability in parliamentary setting. Because now I would ask him to be mindful of the time, so not unless he wants to filibuster. So I actually was going to raise that when I had more time. I'll leave it rhetorical now if Mr. Chan wants to answer. But that's where I'm having a problem, is how is that not speaking to competency and asking someone on a particular subject, how would you view this? What were the traits and the characteristics you would look for in a candidate coming forward? And to be told that that's not competency leaves me wondering, what is competency then, if not that? So anyway, those are my points. I'll defer to the time at hand and my remarks so that we can have the vote.
Okay. Well, we've got Mr. Chan, and we've now had Mr. Graham at it as well. But Mr. Chan, the floor is yours. I do hope that we can be brief, and then we can have the vote that it appears that the committee desires.
Thank you, Mr. Chair. I first of all wanted to get back to Mr. Reid's point before I turn to Mr. Christofferson's point with respect to the ring. And I simply wanted to note on the record that my wife has just arrived, and I wanted to just note, Jean, welcome. If there's any ring that any... The only time I defer with respect to the ring is the vow that I made. With respect to the broader point, I would simply say on the record again, Mr. Reid, we find ourselves in the situation because of the actions of the previous government. We're now faced with the potential of 25, I understand now, vacancies before the Senate because the previous Prime Minister chose not to make appointments for over 2 years. And so we are now faced with the situation of where we have a constitutional requirement to have a functioning upper house where we need to appoint this rather large number of senators, including someone who will ultimately be the government's representative in the Senate, given that we have moved forward towards greater independence and recognizing the importance of greater independence of senators. And so we are simply faced with this situation. I would also note on the record, too, that at the end of the day, from a constitutional convention, a constitutional perspective, that this advisory board, and this is why I raised the question and withdrew it, recognizing it was a process question, that this advisory board's recommendations to the Executive Council and to the Prime Minister are ultimately not binding on the Prime Minister. It would fetter his discretion. And so at the end of the day, what we're trying to do is create a more open, democratic process for people to apply into a process. Unfortunately, in dealing with a problem that we have right now on short notice with the interim appointments or the interim process, but subsequently trying to invite Canadians from throughout the land of exceptional competence to consider serving in a public way on something that we are constitutionally mandated to do. With respect to your question, Mr. Christofferson.
Well, maybe before you get to that, Mr. Chan, I'll just interrupt you there. If the committee does wish to deal with the budget today, I would probably have to interrupt us at this point and suspend briefly to go in camera to deal with that. Or if the committee would rather use the last 4 or 5 minutes of our time today to continue with this, that is something we can do.
Unless there's a problem, could we not just approve it with UC, with a unanimous consent, and be done in a blink? It shouldn't be controversial.
The budget has been put before you. Do I see any objection?
I'll move the motion. If I can have a second on the other side.
We don't even really need a motion necessarily if the committee is in agreement with the budget as presented. It's all been put before you, so that's been dealt with. Thank you to the committee.
You're welcome.
Mr. Chan,
I have the floor back. Thank you.
The floor is yours. We've got a few minutes left, so just keep that in mind if we do want to see a vote today.
So again, I want to thank Mr. Christofferson, for raising these issues, and I understand the angle that the third party, that the New Democratic Party, has historically held with respect to the Senate. And I understand the kinds of questioning that you have ultimately been presenting. But at the end of the day, we clearly, throughout the electoral process, made it very clear that we have to comply ultimately with the constitutional rules as they stand, right? Which is to have a functioning Senate. At the end of the day, if we do not appoint these senators, we are ultimately left with a situation where we will have one chamber where it is incapable of responding to the passage of legislation coming from the House of Commons. And so I appreciate the point that you are ultimately making with respect to the issues of legitimacy and so forth. And that, as I say, with all due respect, the NDP can rail all they want with respect to the Senate. With respect to the Senate, I have the floor right now, Mr. Christofferson. So please, I granted you the opportunity to put the courtesy to say what you wanted to say. I granted Mr. Reid 20 minutes to say what he wanted to say, and I've granted you the courtesy many times in the past to keep going. So I think I now have the floor, and I have the right to continue to get the points that I want to get out. So thank you, Mr. Christofferson. So getting back to the point that I was making is that at the end of the day, we have a constitutional requirement, okay, at the end of the day, to have a functioning upper chamber so that laws of this land can ultimately be passed. And that is what we're going through. It's what we're going through right now, is to get a process in place that ultimately attempts to create greater confidence in Canadians with respect to to a chamber of second sober thought. Meanwhile, respecting both the constitutional practices and the conventions that associate themselves with respect to the appointment of senators, so that we don't get into the situation that Mr. Reid had previously noted, that we are somehow violating or engaging in a process that is ultimately ultra-virus. And so I, with all due respect, at the end of the day, we're trying to obviously work within the confines and the framework of both the rules that are presented here with respect to the standing orders. And I would also note, too, that we've been open in terms of allowing witnesses to appear before this committee, including the 3 federal appointees. Something, by the way, I would note that the previous government never allowed. They shut down every single motion to call witnesses, okay, before committees for review, because they didn't want their witnesses to be subject to that kind of scrutiny. And we are dealing ultimately with the terms that are set under Standing Orders 110 and 111. And so that's the situation that we're faced with. And as I said earlier, I invite the members, as we go through the process that this committee will ultimately have the opportunity to do, is to review the standing orders. If you don't like the way they're written right now, we can make and propose those changes, through that appropriate process. But let's not rewrite the rules now just because you find them inconvenient, because you've got a different political point to be made. And so and also to answer your question with respect to what is competence, that is why, and I think if you actually listened carefully to the witness that we had there today, Dean Jutras, he made it very clear. Look at my historical practice. Look at the kinds of circumstances and situations in which I dealt with these types of particular issues.
Mr. Chan, we are at 1 o'clock, and I know I have had some members tell me that they do have other meetings they have to get to. I think we'll probably have to end here for today. It doesn't appear as though we'll be able to have a vote today.
Can I just conclude my comments and then cede the floor?
How much time do you need, Mr. Chan?
No, actually, I'm prepared to now cede the floor to Mr. Graham, but we'll take it up at the next meeting.
So what I was going to suggest to help the committee with this, it appears as though we won't be able to have a vote today unless we have consent to continue for some time, and I know I do have members that do need to leave. Mr. Graham, did you wish to have the floor, or can we proceed
I'd be happy
to
to start the next meeting if you'd like.
Okay, well, it doesn't appear as though I have consent from Mr. Graham to cede the floor to enable a vote, so we'll have to continue this. What I would maybe suggest to the committee as a potential option for this, I do see on March the 8th, we do have the Order in Council, the other Order in Council appointee set for the first hour, and the supplementary estimates scheduled for the second hour. If we felt as a committee that maybe we could shorten up each of those two things, go to 45 minutes or something along that lines for each of those two items, we could leave ourselves a bit of time at the end of that meeting to continue with this motion and have it dealt with. I know that there is some timeliness to it, given that it's requiring the witnesses to be here prior to the end of March. So it might be a good idea, given how little time we have in March here in committee, to try and deal with it. Is that something that would be agreeable to the committee, that maybe we would ask that be done and we shorten those two to 45 minutes per panel, and then we can dispense with this on the March 8th meeting? Is that something that would be agreeable? It sounds as though it's agreeable, so we'll make that suggestion, and our clerk can make the necessary adjustments to the agenda. Thank you all, and the meeting is adjourned for today. Meeting adjourned.